Be ready? Start. To the respondent to select any one from the panel sent by the respondent after the expiry of the period for selecting a person by the petitioner stop. In this case, since the respondent has already exercised the arbitration clause and already replaced and selected a sole arbitrator in place of Justice R.S. Pathak within bracket since deceased who has already entered appearance, I do not find any reason to replace the appointed arbitrator at this stage when admittedly no allegations have been put forward by the petitioner against such appointment excepting that since a former Chief Justice of India was appointed to arbitrate the disputes between the parties. This time, also a former Chief Justice of India ought to have been appointed stop stencha. Learned counsel for the petitioners has primarily emphasized that learned prescribed authority while rejecting the application moved by the petitioners for cross-examination of the witnesses produced by the plaintiffs has erred in law stop. He has also stated that while rejecting the application seeking permission to cross-examine the witnesses, the learned prescribed authority has not assigned any plausible reason therefore stop. His further submission is that a specific ground was taken by the petitioners by filing appeal before the appellate court against the order dated 22/12/2012 passed by the prescribed authority that learned prescribed authority has wrongly rejected the application seeking opportunity to cross-examine the witnesses but learned appellate court has also not considered the said prayer in its correct legal perspective stop. In this regard, he has submitted that application made by the petitioners before the appellate court was rejected on 22/11/2014 with the observation that the issue will be considered by the appellate court at the time of final hearing of the matter. However, while rendering the final judgment, the appellate court has not considered the said prayer and has also not taken into account the ground raised by the petitioners related thereto by observing that the application made by the petitioners stood rejected earlier and as such there is no justification in considering the said application stop stencha. Apart from the aforesaid ground of denial of opportunity to cross-examine the witnesses, learned counsel for the petitioners has also stated that in fact the findings of fact recorded by the learned prescribed authority which has been affirmed by the appellate court in respect of bona fide need and comparative hardships is also against the evidence available on record stop. On the other hand, learned counsel representing the respondents has submitted that in the facts and circumstances of the case, no interference by this court is warranted in the judgment rendered by the prescribed authority, which has been affirmed by the appellate court stop. He has also stated that in absence of any provisions under UP Act number 13 of 1972 permitting cross-examination of the witnesses, there is no illegality which can be said to have been committed by the prescribed authority in denying the said opportunity to the petitioners stop. Taking up the first argument raised by the learned counsel for the petitioners, I may only refer to the contents of the application made by the petitioners before the prescribed authority stop. The said application is on record stop. According to the said application, it was submitted by the petitioners before the prescribed authority that under the changed circumstances the respondents have put wrong facts in respect of shop which is adjoining the premises in question and was earlier in the occupation of another tenant Ram Raj Prajapati stop. It was further stated in the said application that earlier the learned prescribed authority had rejected the application for issuing commission, and as such it would be in the interest of justice that in respect of the fact deposed by the witnesses produced by the respondents, the petitioners may be permitted to cross-examine them concerning the statement made in regard to the shop stop. The said application was dealt with by the prescribed authority, who by means of the order dated 22/11/2012 rejected the same stop. While rejecting the said application, learned prescribed authority has given adequate reasons stop. Reasons given by the prescribed authority are to the effect that he was satisfied from perusal of the record that it has been deposed that the shop which was earlier in possession of Ram Raj Prajapati has came in the possession of the respondents plaintiffs on the basis of a compromise stop. Learned prescribed authority has also stated in the said order that the plaintiffs have only stated that in the said shop the wife of plaintiff and Srimati Draupadi themselves are doing some business relating to certain articles relating to ladies, which fact has been corroborated by the statements made by other witnesses. Stop stanza. In the instant case, here the allegation was of incorrect periods of experience mentioned in the certificates stop. That was short to be explained by the petitioner through the information given, which has also been alleged in the writ petition, but the fact remains that the verification was carried out by the Medical Council of India and not by the central government stop. It is in this context that an opportunity by the Medical Council of India was necessary to be given for confronting the petitioner with the material that was to be used in this regard to withdraw the recommendation stop. The authority to recommend, in our opinion, also inherently in a matter of alleged misrepresentation or fraud possesses the power to withdraw the same stop. Such power deserves to be read to uphold the object and purpose of the function assigned to an expert body to recommend, namely the Medical Council of India stop. We cannot be oblivious of the general principles of administrative law in an allegation of fraud or misrepresentation so as to denude the expert body of its power to withdraw recommendations or treat it to have become functus officio even if such fraud and misrepresentation has been detected stop. If after such opportunity a finding would have been arrived at, then in that event the endorsement on the declaration given by the petitioner college as extracted in paragraph 60 of the counter affidavit could have been pressed into service for withdrawal of recommendations stop. The endorsement ipso facto without any opportunity to the petitioner by the Medical Council of India would not operate adverse to the petitioner unless the said exercise is carried out stop. The petitioner no doubt had an allegation to make a correct declaration, but the petitioner should also have the opportunity to explain as to under what circumstances the certificates of the faculties had been tendered, believing it to be true stop. Collusion and fraud are not terms of ornaments stop. They entail serious consequences, and in such matters where the penalty is harsh, then the observance of the principles of natural justice becomes more necessary stop. It is for this additional reason as well that we endorse the ratio of the view taken by the full bench of the Delhi High Court to be attracted here in stop stanza. To us, it appears that the central government also overlooked this aspect of the matter while proceeding to communicate the decision impugned herein dated 29/2016 stop. Consequently, for all the reasons given herein above, we find that an opportunity ought to have been given to the petitioner by the Medical Council of India before proceeding to withdraw the recommendation that stop over.